webinar titled Legalized Marijuana in the Workplace, What Employers Need to Know. I'm Jim Grasso. I'm a partner in our Labor and Employment Department, and I'm joined today by my partner, Linda Prestegaard, who's also in our Labor and Employment Department, and we're going to be sharing today's presentation.
Good morning.
Yeah. And so you'll notice there is a Q&A section for you to enter your questions. Should be on the right of your screen. If you have any questions, please go ahead and enter them. We're going to hold the questions until the end of the webinar, and then we will address them as best we can, and hopefully group the ones that are together and get through that. Today, we expect the webinar to last about 40-45 minutes, and then additional time for questions. So once again, thank you for joining us. We'll get started. Thank you. Move on to the first screen. There we go. Okay, so we're here today because recreational marijuana is now legal in New York, and that is the result of the Marijuana Regulation and Taxation Act, MRTA, or if you that's too much of a mouthful, we can just call it the cannabis law, because the statute provides that is the short name of the law. So we'll refer to it as the cannabis law as we go through here. It was signed into law 3 weeks ago, I think today, on March 31st by Governor Cuomo. And this is really a comprehensive marijuana regulation statute. Not only does it legalize recreational use of marijuana and the possession of marijuana in New York State, which took place immediately, it also reforms the medical marijuana statute, which Linda will address. Apologize for that. It also allows for commercial cultivation, processing, distribution, and sale of marijuana. So that is the part where entities will be allowed to form companies that will cultivate, grow, process, distribute it. Those sections of the law are not in effect yet. Those are subject to the new commission that has been created to, much like the Alcohol Control Board, there's going to be a Marijuana Control Board, which is going to have jurisdiction over granting licenses and monitoring people who are involved in the commercial aspects of marijuana. And then there's also part of the statute addresses prior criminal convictions, which will allow people who were previously convicted of a marijuana violation to have that conviction vacated or expunged if that conduct would now be legal under the cannabis law. So it's a way to, that's part of the the social justice aspect of the statute, which will allow those people to go back and clean their records, so to speak. So marijuana, recreational marijuana, it's legal now in 18 states and Washington, D.C. So the trend is growing across the country. The two latest states are, after New York, are New Mexico and Virginia. The legalization in both of those states is not set to take effect until the summer, though, for another couple of months, and Washington, D.C. So as you can see, just over a third of the states in the country now allow recreational marijuana. So if you have operations outside New York in one of those other states, you're going to have to deal with it not only in New York, but in those states as well. And medical marijuana is even more widespread. It's legal in 36 states now. However, keep in mind, marijuana remains illegal under federal law, and we'll get into the implications of that contradiction. Where it is legal at the state level in 18 states and Washington, but illegal at the federal level. Okay, so what is marijuana? Many of us might have a sense of what it is, but there is a legal definition in the cannabis law, and it defines marijuana as all parts of the cannabis plant, the seeds, the resins that are extracted from any part of the plant, And then any compound, and this is from the statute, any compound, manufacture, salt, derivative, mixture, or preparation of the plant, the seeds, or the resin. So it's really a comprehensive definition. Any part of the plant or anything extracted from the plant or any product that is manufactured using any parts of the plant, resins or seeds, is considered marijuana. So it's not just the smokable form of marijuana. So it is quite broad and will include everything. So let's talk about who's allowed to use marijuana now under the cannabis law. Legal marijuana is limited to adults 21 years and older. So, just like alcohol, those under 21 may not legally use marijuana. Adults are allowed now to possess up to 3 ounces of marijuana and 24 grams of concentrated cannabis on their person, and they may transfer that to another adult without compensation, meaning they can't sell it. They can give it away for free, transfer it among themselves, but they cannot sell it. And adults may grow up to 6 cannabis plants and have up to 5 pounds of cannabis in their residence or on their grounds. And the last point there, just emphasizing the transfer of marijuana, 3 ounces and 24 grams without compensation. So there still are criminal penalties for example, if an adult were to sell marijuana or transfer more than the 3 ounces or 24 grams, there still are criminal sanctions for that. However, they've been greatly reduced from what they were previously, but there are still possible misdemeanor and felony violations. But now, for example, to be convicted of a felony marijuana violation, the transfer of marijuana, the amount involved would have to be much greater than under previous law. So what about recreational marijuana in the workplace? It's important to remember the cannabis law does not allow employees to use, possess, sell, or distribute marijuana in the workplace. So similar to alcohol. So keep that in mind. You can still have policies that prohibit employees from having marijuana in the workplace, using it, possessing it, selling it, distributing it, etc. Again, the same type of policies that you have for alcohol and other drugs, which are illegal at the federal level, at least. And also, the cannabis law does prohibit smoking of marijuana wherever smoking of tobacco is prohibited. So you don't have to worry about people lighting up in the workplace, even if you don't have a policy immediately in place, because smoking tobacco in workplaces, is prohibited in New York. And also, so out in the larger community, people will not be able to smoke marijuana, in public where tobacco is prohibited as well.
Yeah, and I think this is an important slide to emphasize. While most of us will have to tweak our drug policies, just because you're going to have to look line by line at the language of your policies, it really, we're going to end up being in a situation as treating it like alcohol. And we can continue to have the policies that we had before regarding marijuana and alcohol use at work. But we're going to want to both look at your drug policy and at your smoking policy. Most of us have a short policy in place, and we're going to include marijuana in that, along if you haven't added vaping, those kinds of things to it as well.
So there are now, in addition to recreational marijuana being legal, there are now workplace protections for people who use recreational marijuana outside of the workplace. So the way this came about is that the cannabis law amended Section 201D of the New York labor law, which is commonly known as the off-duty recreational law in New York. And that law protects employees who engage in lawful activity outside of work. And one of the legal activities that is protected in that law is the consumption of legal consumable products. So the cannabis law expressly makes marijuana now a legal consumable product under Section 201D of the labor law, and expressly protect recreational users from being discharged, discriminated against, retaliated against, or being denied employment because they use recreational marijuana outside of the workplace. And outside of the workplace means off of the employer's premises and outside of work hours. And you'll note that at the bottom of this screen, under the statute, work hours include paid and unpaid breaks in meal periods. So work hours include, as a practical matter, the entire period of time that an employee is on the employer's premises. So again, so that goes back to why employers are still able to prohibit marijuana use, consumption, possession on the workplace. And you can still have those policies, but if the use is off of the premises and outside of work hours, it is now protected, and employers may not take any of those actions, except for certain exceptions that we'll get to in just a second.
Yeah, and I think that this is, I did a double take when I was reading the statute, and I sort of said outside work hours. I was like, oh no, what about unpaid breaks? I literally had that thought. And then I think maybe it was the next line of the statute, they gave us a definition of work hours, which can obviously differ in other circumstances for other laws. So this is something to think about and just be aware of. So that was one of those double takes I did when I was reading the statute. Note that the bill is 100 pages long.
Yeah.
And as Jim said, it's actually very, very complex because, as you can see from the beginning of the first few slides, we talked about it allows for all the commercial cultivation, processing, and distribution. So in essence, the statute, in addition to dealing with the employment issues, deals with the whole process of setting up a marijuana business and basically a marijuana control board, like we have a alcohol or liquor control. This statute is very complex. And so when we were going through it, you're sort of reading along and trying to figure everything out as we go through it. So this, I thought, was one of the more interesting little provisions that they definitely gave us a good definition of work hours.
Keep in mind, premises, workplace premises would include parking lots.
Yeah.
If you're thinking of having a policy that will prohibit employees from, possessing marijuana in the workplace, I think you will be able to also prohibit them from having it in their vehicles while the vehicle is parked on your workplace. And you'll see that the protection requires that the use be off of the premises and outside of work hours have to apply. So if you have an employee who is traveling or off of your premises, but is, they're traveling for work, etc., you can still prohibit the use of marijuana, during the work hours, even though they are off your premises. So I mentioned there were a couple of exceptions to workplace protections. So the law does carve out 3 areas, circumstances in which an employer can take adverse action against an employee for using marijuana, recreational marijuana that would otherwise be protected if it was off the premises and outside work hours. So the first situation is where the employer's actions are required by state or federal statute, regulation, ordinance, or other state or federal government mandate. So that simply means if you are subject to some other law, rule, or regulation, whether it be at the state or federal or other level or other mandate, that you can comply with that requirement, those requirements, and if they require that you take certain action that would otherwise be prohibited against someone using recreational marijuana, you can take that action. So this is a situation where the statute is giving precedence to other laws that say, you can't allow someone to operate machinery, or I'm thinking Department of Transportation regulations for driving, etc. Yeah. The second Yep,
Yeah, that's
sorry.
going to be a real issue for folks, and we can already see in some of the questions to the panelists. So we will answer some of your questions regarding these issues, but this is going to be one of the ones that folks are going to be able to rely on is the state and federal statute exceptions.
Yep. So the second situation where an employer will be able to take adverse action for recreational use would be if the employer's conduct would require it to commit any act that would cause it to be in violation of a federal law or would result in the loss of federal contractor funding. So when they say employer conduct, that's not defined, but I interpret that to mean if you tolerated the recreational use, that would be the conduct. And if there's some other federal law, et cetera, that, if you tolerated that conduct would violate federal law or result in the employer losing the contract or federal funding, that would be a situation where you would also be able to take adverse action. So, for example, a situation where if you're a government contractor, whatever agency, and if there's you're subject to specific federal regulation regarding employee drug use, and if those regulations require that you take certain action for someone who's using illegal drugs, including marijuana, that is going to be permissible. And the last situation where you can take adverse action is if the employee is impaired by marijuana use. This is the broadest exception and probably the one that's going to cause the greatest confusion and take a while for it to work out and for people to become comfortable with it. And the reason for that is under the labor law, section 201D, it specifically defines what it means to be impaired, or I should say, how you can prove someone is impaired by marijuana. So under the statute, someone is impaired by marijuana when they manifest specific articulable symptoms while working. And the question is, well, what are specific articulable symptoms? And the statute does not provide any guidance. It does not list what symptoms would constitute marijuana impairment. And the issue here is there really is no universally accepted symptoms of marijuana impairment. From a medical point of view, I think we all understand there are certain symptoms that might indicate marijuana impairment, but there really haven't been any that have been adopted by any agencies. And also, there is no accepted level of THC, the active ingredient in marijuana, for someone being impaired. We all are familiar with alcohol. In New York, the level is a 0.08 level. You're legally considered impaired. There is no equivalent level for THC concentration in your blood for being considered impaired. So that is a significant difference. So, and not only must there be specific articulable symptoms while working, but those symptoms have to decrease or lessen the employee's performance of his or her job duties, or the symptoms must interfere with the employer's obligation to provide a safe and healthy workplace free from recognized hazards as required by state and federal law. So that's kind of a general duty clause. And as I mentioned, the law does not define what is specific articulable symptoms of marijuana impairment. So as a result of this, marijuana, to discipline someone, or I should say to determine if they're impaired marijuana now, and so to be able to take adverse action for being impaired, employers are going to have to be able to document and support that the employee was indeed impaired because they showed specific articulable symptoms of marijuana impairment while at work. So that, of course, begs the question, what type of symptoms would be sufficient? As I mentioned, the law does not identify them, so there's no guidance. If it were ever to go before a judge, there's nothing that a judge could look at and say, yes, you prove this, and therefore it's impairment. There's no guidance from the Marijuana Control Board yet. We may get that. We don't know, but some of the commonly accepted symptoms of marijuana impairment include those listed here on this screen. So bloodshot eyes, decreased reaction time, decreased short-term memory, poor hand-eye coordination, lack of concentration, decreased perception of time and distance, dry mouth, euphoria, or a relaxed state. So, those symptoms are, I think, generally accepted among the lay community and possibly to some extent the medical community as being symptoms of marijuana impairment. So, those are the things I think right now employers are going to have to focus on if they're going to discipline someone for being impaired at work, because it is now. In fact, I'll just follow up that recreational marijuana use is now legal. Drug testing alone is not going to be enough to discipline an employee, and Linda is going to address that in the next section. So that's a summary of recreational marijuana in New York right now. As I said, it has been legal for the last 3 weeks. And for the last 3 weeks, employers are now prohibited from taking any adverse action, refusing to hire employees because of their use of marijuana outside of the workplace. So, that is going to change dramatically a lot of employers' drug and alcohol policies, and there are going to have to be revisions to those, which we'll address. So,
yeah, we're going to address that. And I think that the other thing that is so interesting is this is a list that I've seen as well for being impaired. But as I was looking at other states' statutes, there are other states that have very different lists of sets of methods of showing that somebody's impaired or symptoms as they're listed. So I do hope that we get some guidance from the Marijuana Control Board about what we can look for, but it's going to be very important that as employers that we train our supervisors, and we're going to discuss this a little bit further, but I want to really concentrate on this list because we're going to have to be very articulate in what we see if we believe an employee is impaired. You can't just say he was acting strange or something along those lines. We're going to want to point to very specific indicia of impairment before we discipline somebody.
So before I turn this over to Linda to continue with medical marijuana, just note, of course, if an employee engages, in improper conduct or whatever conduct in the workplace, it's still permissible to discipline an employee for conduct,
right?
Whether or not it's related to drug use. So if you have a situation where an employee engages in such egregious conduct that it's grounds for immediate termination, you can of course still take action based on the conduct, and perhaps not even be worried about whether they were impaired or not, because of course acting on the conduct is separate from acting because someone might have been impaired. So with that, we'll move on to medical marijuana, and Dave Ernst is our technical assistant today. And Dave, if you could.
There we go. All right.
Linda.
Okay, now I got it. Take control. Do my little thing. Okay. So medical marijuana, we already have experience as employers with the use of medical marijuana. And under this statute, that is still recognized, and we get more guidance in the statutory language in the cannabis law. We now know, and we knew this before, but there's now a definition, and we've got a healthcare provider that's licensed to prescribe controlled substances in New York State are the only providers that can write prescriptions for medical marijuana. And the prescription has to be for a condition specified in the patient's healthcare record. So the conditions, this ends up being actually a very interesting issue. The conditions are listed in the statute: cancer, positive status for HIV, AIDS, ALS, Parkinson's, multiple sclerosis, damage to nervous system, epilepsy, PTSD, Alzheimer's. There's a long list, But the most interesting piece of the legislation for medical marijuana purposes is that it says, or any other condition certified by the practitioner. So we are going to be, we're going to have to see how this develops in terms of what medical marijuana is going to be prescribed for, because we're then going to be in the situation where we as employers are going to be asked to accommodate this use of medical marijuana. And I'll get to that in a minute. There are no longer any restrictions on the form of the marijuana that the patient can use. No longer restrictions on the method of consumption or the drug potency. The patient is going to have to get a registry identification card. And now medical marijuana can be prescribed for any person regardless of age. And significantly for us as employers, persons using medical marijuana are going to be deemed as having a disability under the New York human rights law. So we automatically get into the definition. They qualify as a disability under the New York human rights law. And that moves us directly into the next issue of talking about a reasonable accommodation for somebody's need to use medical marijuana. We're going to be in a situation just like we do with other disabilities, where we're going to assess the essential functions of the job, and we're going to have to engage in the interactive process with respect to whether or not we can provide a reasonable accommodation for somebody's medical marijuana use. They're going to be subject to the medical marijuana users are going to be subject to the same workplace restrictions as the recreational marijuana users, and they can be prohibited from working while impaired. I think that's very significant. I think that in the end, our accommodations are going to be workarounds, maybe with respect to hours that the employee works. If there's a timing issue as to when their pain is and or when the medical marijuana helps them. They don't have to be accommodated if doing so would put the employer in direct violation of federal law or cause it to lose a federal contract or funding. So we're back into the process that if you are a federal contractor, or if you're receiving federal funding, or there's some other federal law that applies, that you're going to be in a situation where allowing the use of medical marijuana by one of your employees is going to jeopardize your federal contract funding, or it violates a federal law that you have to comply with, then there will be an exception and you won't have to accommodate that particular user. So one of these pieces, are the employer not subject to a contrary legal requirement can no longer prohibit employees from working with marijuana in their system. This bullet you have to think a little bit about, in that marijuana, when you're testing for marijuana, the test can show positive, but this marijuana could have been smoked or otherwise ingested over a relatively long period of time. I've always said 30 days, but there isn't a specific time that the marijuana is going to stay in someone's system. But because this is what puts us into the problem with the testing for marijuana, in that someone could use it a week ago and they would still test positive. You can prohibit, as we've discussed, somebody working while impaired, but they have to show specific articulable symptoms. So we went through our list earlier, and you're going to be able to email us and we'll send you a copy of the slides if you want them. But we're going to be working on this. Is going to be a work in progress in terms of what the symptoms might be and how we're going to articulate them. But we are going to be looking and following along any guidance that we can obtain on this subject. Employers are going to be able to discipline for conduct in the workplace, just as Jim said, regardless of the cause. Now, this happens with all disabilities. If I've got somebody that I'm accommodating who has a disability, but they continue to violate our policy against maybe harassing somebody or engaging in some conduct that is interfering with another employee, and I can't come up with a reasonable accommodation, I can still ultimately terminate that employee for misconduct. And the same is going to apply here for medical marijuana users. If it's disciplinary, I mean, if it's misconduct, then we're going to be able to discipline for it. So here's an interesting issue. It is still legal to test pre-employment for marijuana in New York State. Now, I want to show that there's a very big exception for New York City. It is not legal to engage in pre-employment testing for employees in New York City. But we may no longer deny employment based on a positive pre-employment test for marijuana, unless you are permitted to do so under the other laws or regulations that we've been discussing, such as if you're a federal contractor, or if you're receiving federal funding, or another federal law applies to you.
Yeah, Linda, let me just mention for the exception in New York City to for marijuana testing, it is generally prohibited.
Yeah, there are exceptions. Yeah,
there are exceptions similar to the recreational marijuana as well. So
exactly.
If any of you have employees in New York City, there are exceptions, but they're very limited, mainly to safety sensitive and those required by law.
Yeah, and there's certain positions too that you're obviously going to be able to test for in New York City. I mentioned New York City because I'm practicing quite a bit in New York City, and there is not a lot of forgiveness by the city commission violations of human rights law, and employers in New York City know that we are very, very careful with regard to these variety of statutes that apply. But exactly the same rhythm occurs. If there's an overriding statute, then that would also apply for New York City. So the question becomes, if you're not required to conduct pre-employment testing for marijuana for other bases, such as like being a federal contractor or having a federal law apply, then what you're going to think about whether or not you're going to do this pre-employment testing, then, or not the pre-employment testing, drug testing overall, but the marijuana pre-employment testing, because what happens if you get a positive test result coming back on the marijuana, but you are denying the employment for another reason? I think that's going to cause you some significant risk. Jim, I don't know if you have a different thought on that, but I'm going to be advocating to not engage in pre-employment testing for marijuana when you conduct your tests, because I don't think I want to know those results with respect to somebody that I'm going to be hiring.
Yeah, I think that's going to be the situation for most, if not all, employers, except for those who may be subject again to some other federal or state requirement, because you can see at the bottom of the slide we have the question of, if you cannot act on the results, why test? And of course now, trust me, it's not going to be long. I'm sure everyone who uses recreational marijuana in New York is aware that it's now legal. And if they're not aware that they have job protection as a result of that, they likely soon will. So now, if someone is a recreational marijuana user and they apply to you and you send them for a drug test, and you test them for marijuana and deny them a job, it doesn't take much for them to go down to the Division of Human Rights and now file a charge or get a lawyer that, they say they think that you denied them employment because, they tested positive for marijuana.
Yep.
You're not going to share that drug test with them. They will know that they're a user, of course, and they will assume that you've tested them for marijuana. So,
yeah, I think it's something that you're really going to have to think about. Now, you are permitted to continue to test for marijuana use during the course of an employee's employment. If you have other testing rules for your drug policies provide for testing for things like accidents maybe, or if you have random testing for particular reasons. you're particularly going to do it like for Department of Transportation. I think of commercial driver's license that requires random testing. And you're going to be able to take action accordingly. And you're going to be able to take action based on a positive test if doing so is going to require you to maintain your federal contract or your federal funding. The major issue here is, and the thing that is going to be every employer's, well, what we're really going to have to think about as employers is that you cannot alone, or you cannot use a positive test alone to establish impairment if you're going to be testing. You're going to want to make sure that if you go ahead and test somebody, or particularly for marijuana, because they're showing signs of having used marijuana and are impaired at work, you're going to want to have the other indicia that we've talked about noted down and documented. But then I believe that a positive marijuana test would add weight to that impairment determination, especially if an accident is involved.
Right. So if there is an accident and you observe the employee and you determine, yes, they're exhibiting these symptoms of marijuana impairment, and then you send them for a drug test, marijuana test, and it comes back positive, well, then that again, will support the determination. Well, this is someone who uses marijuana, which would make, which would make a conclusion that their impairment was caused by marijuana. A stronger conclusion. Won't be definitive, but I think would help.
And I agree. And but you're going to really, this is where we're going to end up getting to the point where we're really going to have to train supervisors and managers to recognize and document the signs of marijuana impairment. So these are our, I would say, this is what we're going to have to do now that the law is in place. And these are the steps that you should be doing immediately. You're going to need to look to see and determine, and most of you will know, whether or not complying with the cannabis law is going to jeopardize a federal contract that you may have or some federal funding that you have. If you are, then you're also going to determine whether you have other actions that you have to take, either by federal or state law, that might be prohibited by the cannabis law. So you're going to have to look at all of these issues, and we're going to have to dovetail the other laws that you're complying with. I think we talked about at the very beginning, but you're going to review and revise your drug policies as needed. You're going to review your pre-employment and during employment testing policies and protocols. I think the protocols part is where you're really going to be looking at what's happening at your pre-employment level of the drug testing. Then let's talk a little bit about how you're going to train your supervisors. I think everybody, so Jim, why don't you talk a little bit about that? Because I think this is the piece that is going to be the most difficult in terms of how we're going to operate going forward.
It is, again, because the statute doesn't identify what signs of impairment would qualify as marijuana impairment. I think employers are rightly so going to want to rely on medical expertise for what is accepted, and however you determine, if you work with a medical professional, but then you're going to have to, I think, train supervisors, and that may be, require bringing in people who are police officers or, people with law enforcement backgrounds who have that experience, or medical professionals, to train employees about what signs would indicate marijuana impairment. For alcohol impairment, alcohol is so widespread, so common. The courts and administrative agencies, right, will accept a lay person's assessment that, well, they had the smell of alcohol on their breath, their eyes were bloodshot, they were slurring their words, etc. And you don't need any expert to testify about that. I don't think we're at that level yet with marijuana. We may get there, but until we do, I think we're probably going to need some professional assistance in training people until there's a widespread acceptance of exactly what the symptoms are. But training supervisors, again, maybe, you bring someone in, you spend time with them, but at a minimum, I think you would want to sit down with the supervisors, distribute a list of the commonly accepted indicia of marijuana impairment, and, go over that with them so that they do have some underpinning and understanding of what those things are. And then, of course, have a system to document that.
Yeah, I think that's going to be really critical. You're going to want to note, and not one of these symptoms is going to do it. Somebody could have bloodshot eyes for a different reason, but you're going to want to do the specific symptoms and not just this impression that the person is off. You're going to want to have, if the person was somehow, having poor hand-eye coordination, if that's something that the supervisor could notice. If there's a specific example of the person speaking in a slurred manner or slowly, a variety of things that anything that's specific, I should say, not a variety of things, but it's the specific instances and examples that you're going to want to note so that you can have a basis for forming a good faith belief that the person is showing signs of marijuana impairment. And we're going to have the same conversation again regarding this reasonable accommodation issue. I think that you're going to have to go over with your supervisors, managers, HR folks, that along the same lines that if you have a program where you direct everybody to HR, then that's helpful in terms of the medical marijuana reasonable accommodation. Usually, though, you're going to end up having to involve the supervisors and managers to discuss the job duties and to see what we can and can't accommodate and how we can come up with a reasonable accommodation. And it's a similar requirement of having the engaging in the interactive process that you do with any other disability, because what you're now going to realize is that medical marijuana is by definition a disability under the human rights law, or the use, the prescription of medical marijuana. So,
but let me touch just on drug policies again. I think many employers' drug policies have wording that say something like, we prohibit alcohol and illegal drugs in the workplace.
Yeah, it's not going to help you.
Because marijuana has been illegal at the state, was illegal at the state and federal level, that covered everything. But now that it is legal at the state level, if you leave that as is and simply say drug and illegal, alcohol and illegal drugs, I can certainly envision a situation where if you terminate someone for having marijuana in the workplace under your drug policy, that they turn around and say, well, I didn't violate the drug policy because marijuana is no longer an illegal drug, under the state level. And of course, we'd say, well, it's illegal at the federal level, and you get into that. So to avoid that type of confusion, we'd recommend that when you review your policies, that it probably makes sense now to specifically identify marijuana as being a substance that cannot be used in the workplace, can't be possessed, distributed in the workplace, etc., so that there's no confusion about that.
Yeah, I agree, and I think that that's going to be the trickiest part. And I think all of us are going to be a little rough in terms of reviewing these policies at first, but I think that is going to be one really key component, after the word alcohol, marijuana, and then you're going to be in much better shape in terms of your actual policy. But like I said, I think every policy is going to need some sort of a tweak, so take a look at it. And if you're a school or a college or a university, you are also listed in the statute as not being permitted to refuse enrollment or otherwise penalize a person for conduct that's allowed under this law. Again, except if you're going to lose money or a license related to the benefits under a federal law or regulation, and or if you have adopted a code of conduct that prohibits cannabis use on the basis of a sincere religious belief held by the school, college, or university. I just thought I would add that. We have a lot of employers that are institutions of higher ed, and there's a variety of things in this statute. So we're going to be digging in and update you as things become as they become clearer, once we get some more guidance and or once we start to have experience, I think, applying the statute as well. It's so new that it was very difficult when the medical marijuana statute came. And I think this now is going to add another layer of difficulty for our employees. I think we have a lot. So to end it, we're not ending, but we're going to do the questions. We're going to try to answer some of your questions. But if you want a copy of this presentation, that's me and Jim, by the way, you can email Kathy Gibbons, kgibbons@phillipslytle.com, and she'll send you copies of these slides. No problem.
All right. Yeah, we can move on to the questions. It looks like we have right now about 13, so hopefully we can get to all of those. The first one is if we are a hazardous work industry, such as chemical or DOT, can we still have random testing and discharge employees for testing positive? What do you think, Linda?
So yes, I think you're going to likely have some statutes that require you to do testing. Commercial driver's license, Department of Transportation, I know has them. But there again, you're going to be wanting to be in a position where it depends what that particular federal statute or other statute states. Is if it states the person can't have any marijuana in their system, then that may be an overriding piece. If you are looking at somebody, again, being impaired while at work, which probably wouldn't be the random testing, but some other reason for testing, then you would want to have other indicia of marijuana use other than the testing. But again, you can engage in testing, and you're going to have your exceptions with respect to the statutes that apply to you other than in addition to this cannabis law.
So if there is no overriding federal statute, just because someone is in a safety sensitive position does not exempt them from the law's protections.
Right. Yep. And that's exactly right.
Yeah. Next question is asking if the law covers people who are working from home.
I know, it's a great question.
That is a great question.
It is. So I saw the question in the box when it came through, Jim, and my answer is it's prohibited on work hours, but I don't have the statute. I don't have the statute up.
Yeah, it does. As we said, that the work hours, the two requirements for recreational uses, it has to be off the premises and outside of work hours. So. And the reason for that obviously is, you shouldn't have to have an employee who's under the influence or who is impaired while they're performing work for you. So I think, yes, as I mentioned before, regardless of where the employee is, if they are on work hours, they are not protected. So,
yeah, I think this is going to be interesting. Yeah. And I think that. Yeah, I'm thinking back to your first question too, sort of a safety sensitive position. That could be almost anything. Yeah. You know what I mean? It's going to be, and I'm going to see, you can see some of the questions that were coming down here in what's the next one you want to do? Yeah,
it's just interesting if you have an employee working from home and if you think they're impaired, it might be a little difficult to determine over Zoom.
Yeah, I think that's exactly right. I mean, that's partly what we're going to be dealing with, right?
Yeah. Next one here is, would you recommend to requirements? I'm not sure. It seems to be a requirement for DOT qualified employees. Oh, and a policy for non-employees. I see. I think the question is asking, would we recommend having a drug policy for DOT covered employees and one for non-employees? Well, I think certainly
non-DOT covered employees. Yeah.
Right. Sorry. So I think, if the DOT regulations, impose certain requirements and obligations regarding drug testing and drug use among those people subject to the DOT policies, then you would want to have a separate policy for them because, those rules would not apply to your other employees, right? So you have distinct groups of employees who are subject to two separate rules. Okay.
Yeah, I agree. You would want to have two policies, or at least sections of your policies.
We have a question here is, how does this law impact safety sensitive positions where staff are responsible for care of youth, such as transporting youth, etc.? That goes back to Linda's explanation on the first question. It's going to depend. If there are overriding state or federal rules or regulations, you get to apply those. But if not, then you can only take adverse action if you can show that they're impaired while working. Okay.
Yeah, and I think what I've been trying to do is think about it like alcohol, right? Basically what's happened, and I don't know if you've taken the same approach sort of mentally for this, Jim, but I'm thinking about it as marijuana is now a legally consumable product, and as is alcohol. And people are allowed to drink during non-work hours as long as there's
Right.
time for that alcohol to be ingested. And I think it's the same approach for marijuana. And they will be working in safety sensitive positions. And, you can't come to work on Monday impaired. So that means that you need to stop drinking at a certain time on Sunday or even Saturday, depending on how long it takes you to process the alcohol. And I would say that the same issue is going to be for marijuana.
So next question is, are supervisors allowed to video record an employee to document impairment? So Linda.
So I think that I recommend that employers have policies regarding whether or not they're going to record employees in any event. I don't recommend it. Jim, what is your, I suppose if the employee is very impaired, a video might be useful.
Yeah, I hadn't given it thought, but I think you might be able, you can have policies, for example, to record employees when they're using phones during work. And you might be able to adopt a policy that says the employer reserves the right to video employees when trying to determine impairment, make that a condition of employment. And of course, the way I would envision it would be you'd ask an employee who you might suspect is impaired if you have their permission to video them. You're asking them questions. And if they refused, that if you have a policy in place, that might be a reason in and of itself to terminate them, much like refusing to, go for a drug test.
Right. So that's why I start my answer with those that I really actually prefer a video or a recording policy be in place. And you're going to have some employers that have an opposite rule where video recording is not permitted, particularly if they have customers, clients, patients, et cetera, that can't and shouldn't be recorded. So that's something also to think about.
Yeah. Next question is kind of, I think, a comment. Someone commenting on the impairment of cognitive skills and why the chemical industry is, recommends we maintain prohibitions on cannabis. I understand those concerns, but we now have this law, and this is the impact on employers. So
yeah, they're anticipating it to be a huge moneymaker. If you look at the statute, it's what's the actual title of it? It's tax, what's it called?
Oh, marijuana, it's a taxation act,
Yeah, exactly. So really, there's two. There's criminal justice, but also funding. It's anticipated to be a huge revenue generator.
Yeah. One of the questions was, the next one is, let me see here. Should we be aware if any of our staff use medical marijuana? Are we able to ask? And I think I saw another question asked, must employers inform an employer if they're using medical marijuana? So I'll go with that one. Is an employee does not have to inform that they're using medical marijuana, just like they do not have to inform them they're using any other prescription drug.
Right, or if they have a disability, unless.
And then the question is, should we be aware if a staff is using medical marijuana? Again, you need to treat it just like any other medication now, so you can't be intrusive. You would only be allowed to make inquiry if you had an objective basis to believe that the employee's work was impaired, and ask the employee to explain what's going on. And as we all know, many times when you do that, an employee say, oh, yes, I've been prescribed this new drug and this is what I'm taking. So I'm not going to be able to force employees, though, to tell you that they're either using recreational marijuana or medical marijuana.
Right.
Question, what about situations where an employee may need to be on call? I'm not sure if they need to come. Linda, what do you think?
Well, I believe if you if you have an employee on call and you tell them that they are on call, then part of your rules for being on call would be that they cannot be impaired, whether that be through recreational marijuana use, alcohol, or medication. So that's going to be an issue that you're going to have to make clear that somebody is actually on call. And it's not a maybe. Do you know what I mean? Somebody's got to be told when they're on call or not, or am I misunderstanding the situation?
No, I think that's right. So next question is just asking for clarity. If there's a hazardous work environment, say a lineman for an electric company, we avoid random drug testing. Well, I think Linda addressed that of, unless you're subject to some overriding state or federal requirement. So if you do random drug testing and find out that the employee tests positive for marijuana, that in and of itself is not taking any adverse action.
Right.
So you have to ask yourself, what's the utility there?
Yeah, but I don't, I'm still on the fence. I have to think about that more, but I think the question really is, what are you going to do about the information that you learn, right? It comes back again that now you know that somebody is a recreational marijuana user, but you can't take action unless you have some indication that they were actually impaired while working. And now you have information, and I consider it information very similar to when I know about somebody who has a disability. Just be aware that once that's in your head, it's hard to get it out of your head.
Question about, is testing permitted in the case of a workers' compensation related accident on site? So, whether it's workers' compensation doesn't necessarily come into play there. It's if you have a workplace accident,
right?
And you're going to assess that employee's impairment status, right? Anyways, by determining whether they have any of those symptoms. And as we mentioned, you still have the right to send an employee for a post-accident drug test. But remember, the results of those drug tests, if it comes back positive for marijuana in and of itself, is not enough to discipline. But of course, it would be used in conjunction with the other evidence you have. But
unless it violates some other law, like a Department of Transportation, an overriding federal law should then cover that issue.
Is any testing permitted in the case of a workers' compensation? Okay, sorry, that's the same one. What if they're driving a company vehicle, non-DOT, truck transporting products, or a sales rep driving to customers? Linda.
It's interesting. You can't drive while you're impaired. So you can't be, so the question is what's going to be the value of the test, but we can still have the same issue with alcohol and marijuana. You can't drive while impaired. So again, the value of the test is going to be one question that we have. And then the other question is going to be, or the value of the test is, it's got to be in conjunction with some other indication of impairment.
And again, if they're working, if they're driving, they're at work, you can prohibit them from being impaired.
Absolutely. So that's these are these tricky areas, right? And so we're going to want to make sure we have a policy that now it's still alcohol, marijuana use, all of those things being under the influence, for lack of a better word, while working is prohibited, and it's not protected by this statute.
All right. I think that's the last question, and so we're 11:01. So I think we're on time. So Linda and I thank you for your time and for logging in and letting us present this to you. Again, if you'd like to contact either one of us, our contact information is right there on the page. And if you would like a copy of the PowerPoint, you can contact Kathy Gibbons. Just toggle down again.
Yeah, it's at the very end. There you go. Yep.
You can email Kathy at that email address and ask her for a copy of the PowerPoint. We hope you found this informative and hope you have a nice afternoon. Thank you for joining us.
Bye, everybody.